Welcome, everyone. This is class number 20 of the Ibis Prep MBE crash course for July 2024. And we just had Caro, an amazing guest lecturer, speaker, and motivational person who passed the MBE and the Florida bar on the last administration. And she gave some amazing advice about doing about 50 questions per day, maybe 100 questions per day as we really get down to the wire. So that was awesome. I wanted to share this poll because the presidential debate is tonight, and I want to kind of see where people are feeling with this, and we'll go from there. What I want to do is start off with Jeopardy. So Jeopardy's fun. Everyone loves Jeopardy, and let's play. So can everyone see my screen? No, I bet you can't. Trick question. Can everyone see my screen now?
I can see it, yeah. I could see it before too.
Perfect. All right. Let's start with crimes. So the act of deliberately setting fire to property. Deliberately setting fire to property.
What is arson?
Yeah, everyone's saying arson, arson, arson. Okay. Larceny plus force.
What is robbery?
Robbery, 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 robbery. All right, cool. Obtaining title and possession via fraud. Title and possession, yeah, larceny by. Or is it going to be false pretenses here?
It's false pretenses.
It is false
Larceny by trick is, I think, possession, not title.
Indeed, it is. You almost got me. If it wasn't for dog and his meddling friends. Inchoate crime does not merge with greater crimes.
What is conspiracy?
Did everyone get the Scooby-Doo reference? Or that was not cool enough. All right, what is conspiracy? What is it? It's the inchoate crime that does not merge with greater crimes. That's a good way of talking about it. Unlawful entrance with the intent to commit a crime.
What is burglary?
Burglary, yeah, burglary. Amazing. Walking in on the pool boy with your wife and shooting him, for example.
What is voluntary manslaughter?
Yeah, you're excited about that one. Why, do you have a pool boy situation going on?
No, I literally was thinking about that story like yesterday, so it's funny.
I don't know if it's so like current, but I feel like the pool boy now I feel like would be walking in on the personal trainer, the yoga instructor, or as Tom Brady found out,
The karate man.
yeah, the jujitsu. Oh man, someone just texted me something so funny. It's not funny. Okay, what is voluntary manslaughter? That's the answer. Oh yeah, it's adequate.
The Hawk
No, it wasn't Hawk Tua. They said they were flagged walking in on the tutor with your wife or husband. You know, but we don't condone that type of activity. Okay. Killing someone while texting and driving, for example. The fact that you just yelled Hawk Tua on my class is hilarious to me. Killing someone while texting and driving, for example. What is involuntary manslaughter? Let's go. All right. Premeditated deliberate killing of another is first-degree murder. Let's get it. Shooting a gun for fun into a playground and killing a child, for example.
What is depraved heart murder?
Depraved heart murder. Come on. What is it? Someone who helps a killer after murder but did not participate in the planning or execution of the murder.
Accessory after the fact.
Accessory after the fact. Good job, Safwan, Angie, Hannah. What is an accessory after the fact? The right against self-incrimination.
What is the Sixth Amendment?
Yeah.
Oh, sorry, Fifth.
Fifth Amendment, Fifth Amendment, Fifth Amendment, Fifth Amendment. Good job, Elizabeth. Well, good catch, Elizabeth. Yeah, he's saying Dave Chappelle because that's skit. I plead the fifth. Of all the amendments I could choose, 1, 2, 3, 4, 5. I'm going to show that at the end of class today. So if you want to leave a minute early, you won't get to see it. What is the Fifth Amendment? It'll be a good segue into Trump-Biden debate. Oh yeah, how about those results? Are you guys as excited as me? All right, the right against double jeopardy.
What is
ready-
claim preclusion?
I think it's gonna be an amendment. We're going with amendments here,
Oh,
so
amendment.
where does this come from?
What is the Fifth Amendment?
Fifth Amendment. Yeah. Definitely the Fifth Amendment, it's the same one. Fifth Amendment, so remember, Fifth Amendment is right against self-incrimination, right against double jeopardy, Miranda rights, that's your right to counsel before adversarial proceedings have begun, and then civilly, due process, takings, things like that. This is your right against unreasonable searches and seizures. Fourth Amendment, yeah, claro. I'm so bad at, that's like the hardest part for me in Spanish is the R's and the rest of the language, to be honest. Okay. What is the Fourth Amendment? Your right to counsel after adversarial proceedings have begun. Sixth Amendment, good job. Good job, good job, good job, good job. What is the Sixth Amendment? Your right against cruel and unusual punishment.
What is the eighth?
Yeah, Eighth Amendment. I remember this by thinking like, I don't know, it's weird, but maybe it'll work for some people. Like, okay, handcuffs, you know how they're kind of like a sideways eight? And then like if you put handcuffs on someone and you squeeze it really, really tight and their wrists fall off or something, I don't know, but like I just feel like that concept of like cruel and unusual punishment, really, really tight handcuffs, Eighth Amendment. I don't know, that worked for me once upon a time before I just knew things. At some point you just know things, but at some point you have to have little tricks of the trade. Yeah, Rob's saying maybe they handcuff you in a precarious place. Okay, all right, what is,
What is the Durham test?
yeah, the but for the mental illness would be the Durham test. Good work, Elizabeth. You cannot control the actions because of insanity. Yeah, irresistible impulse test. Good job, Hannah, Jennifer. The irresistible impulse test. You cannot understand the consequences of their actions. Nice, the McNaughton. Good job, Safwa and Angie. McNaughton. Alexis just reached out to me and she said she's wondering if any students need some extra encouragement and all that. So if you feel like that, message me right now. And Alexis will take care of you. She'll give you the options of what tutors are available, what times. You know, we're here to help. Okay, you cannot understand the consequence of your action. We're going McNaughton. Applies either McNaughton or the irresistible impulse test.
What is the model penal code?
What is the model penal code? Good job, everyone. If anyone has any questions, like if I've gone too fast and they want me to go back over something, don't be shy. This is the shyest class I've ever had, which definitely has its benefits for me for sure, but don't be too shy. I've had some really not shy classes in the past that I'm glad they're in the past. So the defense is not, this defense is not constitutionally guaranteed and the burden can be lower than beyond a reasonable doubt. Ooh, this is a tough question. Nice, yes. Insane defense is probably what I'm going for. Thank you so much. Caro, you're amazing, incredible. Let's, we still haven't celebrated. You, me, Hector, everyone else who passed last time. Let's go to like, I don't know, Regatta in the Grove, right by the gym.
You got it. Bye,
Alright.
guys.
Bye. Okay, this defense is not constitutionally guaranteed and the burden can be lower than beyond a reasonable doubt. Yeah, we said insanity defense is what I was going for. Good work. Right, so the insanity defense, it could be eliminated. It could be, the burden can be lowered to below preponderance of evidence. It could be clear and convincing. It could be anything. It's affirmative defense. It's not an element of the crime per se. Prohibits illegally obtained evidence at trial.
What is fruit of the poisonous tree?
I would go before we get to the fruit. Yeah, I would go with the actual tree itself, the exclusionary rule. Oh, Lauren, you're here participating. Good job. And good job, everyone. Hi, multiple eyes. Hi. Hola. Okay, what is the exclusionary rule? Now, here you go. Excludes anything derived from improperly obtained evidence. This is the fruit of the poisonous tree. Hannah, you just said fruit. I'll give it to you. Does anyone still watch Jeopardy? In real life?
Yes.
Yes? Who's the host now? Is it Ken Jennings? Or Aaron Rodgers? You, oh, you said it's Ken Jennings? Yeah, it's Ken. All right, good. Ken was meant for that role. I agree with that. I like Ken. Okay, the standard for statutory rape or bigamy, for example.
What is strict liability?
Yeah, I think that's good. Strict liability. Allows evidence without a warrant if items are in sight. Nice, plain view, plain view, plain view, plain view, plain view, plain view. Maybe if I say it again, you'll get it. Plain view doctrine. A defense that you were somewhere else, for example.
Alibi.
Yeah, you ain't got no alibi, you ugly. Yeah, you ugly. Do you remember that little jingle?
Absolutely.
Yeah, absolutely. Yeah, that's a classic. Right? Yeah, you're with the pool boy. That's your alibi. What was the beginning of it before you ain't got no alibi, you ugly? Like, how did it start?
You say UGLY, you ain't got no alibi. You
Oh, UGLY. You got to spell it out for those idiots, for those boys from Jupiter. Oh, that was it? Wow, 100%. You ain't got no alibi, you ugly. Okay, criminal law. Ready. The moment jeopardy attaches.
Jury's impaneled or
When the jury sworn in.
Yeah, when the jury's sworn in, impaneled. Yeah.
Or when the witness takes the stand in a bench trial.
Or when the witness takes a stand in the bench trial. Good job. All right, I like when the jury's been impaneled. That's kind of what I was going for, but it's all, we kind of crushed it. Okay, amazing. I think we'll take this commercial break to see who's gonna win the presidency. All right, I'll show y'all. We got Biden at 21%, Trump at 63%, not sure yet at 8%, and definitely not voting at 8%. That's the flavor right now. 24% of 27 people voted, so that tells you what it tells you. Okay. Wait, did you guys see the results? Oh yeah. Honestly, when I think of both of those people, Biden and Trump, all I can think of is UGLY. You ain't got no alibi. You ugly. No, right? I'm just kidding.
You know what's funny, Andrew, is that's the exact Nate Silverman predicted. Trump has a 66% chance of beating Biden. So that poll is almost exactly the pulse of America right there.
Is there a place you can take the bet? Like you can take the wager? Is that no?
Absolutely.
Yeah, right. All right. Let's get out of politics. I told you guys I'm running in 2028. I would vote for me. My platform is make education great forever. Okay, let's do that's pretty
We'll
good.
work on that slogan. But
I was just gonna give myself props. Make education great forever. I thought that's pretty good. Okay. Ooh, I cannot have you all looking at my emails. I might have emails from females. No, I'm just kidding. Come on. All right, let's do the Crim Law questionnaire, then we'll do the Crim Pro questionnaire, and then we'll do some Cram Guide activities. We already did the PowerPoint. Remember, it's 2 lectures per subject, so this is just reinforcement. We did amazing on the Jeopardy. Just to show everyone kind of where we're at in the universe. We have the calendar, the calendario, if you will. And we are literally going to have a proctored exam on Tuesday, right? Tuesday, we're going to have a proctored exam. So that makes sense. We've done everything. We'll have a workshop on Sunday, proctored exam on Tuesday, no class on the 4th of July. And then it looks like another proctored exam on Sunday, and then final review, and then class. I tend to do classes, but I think I'm going to make a rule that if you come to my final review classes that are extra, you have to turn the camera on. That's going to be my rule. I don't know if I'm going to record it or not. I probably will, but who knows? And I might relax that rule. I'm known to not care when it comes down to it. Okay, so anyway, scrolling back, this is the calendar. This is when I'm doing the boot camp right here. I don't know if I'm going to be doing Zoom classes in the evening or not. I usually do just to help people out, but I'll definitely be doing my boot camp from 10:30 to 2:30 every day. You should definitely come. It's going to be wild times. I know Sam is doing her Fairy Bar Mother course that starts, I think, next week. You should definitely go to that too. It's super affordable, and she's going to make sure that it's super valuable. And I'll probably just go every time, honestly. Sounds fun. And then the other thing is that we have the syllabus, right? And if you follow along with the syllabus, you should be doing outlines, questionnaires, and doing the quizzes, contents quizzes, and then the 2 quizzes per subject. And then additionally on a commercial Q bank, 50 questions per day. we're bumping it up to 100 questions per day in July, you see? Just stick to the program. The program tends to work. I would try to memorize these questionnaires cold, you know. Caro said that wasn't something she necessarily did or didn't do, but to be fair, she passed on her 4th attempt, you know, so maybe she had already studied this stuff 3 times and that wasn't so important to her. If it was me and I was taking the MBE, I would make sure that I have memorized the questionnaires cold. I've gone over the cram guides that we provided over and over and over and over again. I've created my own cram guide and gone over it over and over and over again. And then I would just run through the questions like I would run them through the wall. Like I would honestly make it a point to do the questions so repetitively that I'm getting them all right, just for the sake of I'm getting them all right. And it's called muscle memory, you know, like unfortunately that works for better or for worse. That works. If you can just get them all right in practice, you tend to pass on test day. And how you're going to do that is different for each person. But if you think about it, a commercial Q bank has 1,600 questions. You know, if you could do every question 3 times, do it the first time for practice, second time to try and reinforce it, third time to make sure you got it, you know, you pretty much should be 90%, whatever, on a Q bank. I'm not saying you need to be 90% to pass, but I'm just saying like, that's got to be like a thought that like, if you can just master these questions that they've given you and get to a point where you're getting them all right, then you are going to pass. Now, that's not necessary. You know, I teach the LSAT. That's like sufficient, but not necessary. Don't even get me started, right? But that's sufficient, but not necessary to passing the bar exam. A sufficient condition to passing the MBE is mastering the Q bank. Fair enough? Mastering the Q bank, mastering the questionnaires, and cramming the cram guides. And I think that's what we're going to focus on as a class. So when it comes to the questionnaires, Crim Law, Crim Pro are split up into Crim Law, Crim Pro. For time's sake, I'm going to go through the completed ones, talk about some things, you know, it'll be just a refreshment. So try to take notes, listen actively. If you stop me, try to make it a good question and let's keep it moving. Don't take that personally. All questions are good questions except the bad ones. So what are the elements of a crime that the prosecution must prove? So the mens rea and the actus rea concurrently and causation, right? They did the thing that constituted the crime and they had the mental state, intent, or, you know, recklessness or whatever it's necessary. So the standard of proof in a criminal prosecution is beyond a reasonable doubt. You remember Jay-Z's album, Reasonable Doubt? Yeah, Jay-Z. I like Jay-Z. I'm definitely a Jay-Z fan. I just think it's funny that he's become so popular in the law because of his music. What is the model penal code? Is it binding? And if not, what is it used for? So the model penal code is a guideline that's not binding, but it's model rules and states are encouraged to adopt, and most states have adopted a lot or parts of it. So model penal code is kind of like the restatement in torts. It's just like, hey, this is how we think we should do it. This is the model penal code. Do you have to do it this way? You really don't. But some questions will require you to know the difference between the model penal code and common law. So, you know, the more you know, the better you'll do on test day, if that wasn't clear yet. So when is an omission or failure to act considered actus reus? When there's a duty to act, like failing to take your kid to the doctor and they die, right? So that would be, you know, you killed the kid. You had a duty to take your kid to the doctor because he was like showing signs of dying and you didn't. You were a causal factor in his death by failing to act. What's the difference between general and specific intent? So general is like battery, reasonably likely to occur as a result. Remember, assault and battery are torts and they're crimes where there's criminal liability. They're pretty much the same, except assault is in the majority of jurisdictions considered a specific intent crime, where it's attempted battery, because attempt is a specific intent. So you actually have to be trying to offensively touch the person for it to be assault in the majority of jurisdictions. The minority of jurisdictions still allow for assault as placing someone in apprehension of battery instead of intentionally trying to offensively touch someone. So the majority of jurisdictions recognize assault as a specific intent crime, which does require, you know, proving specific intent. So there's a mnemonic. A student can fake a bar laugh even for ridiculous bar facts. All right, let's hear it. Let's hear your best fake laugh. See, you guys can't even fucking do it. All right, that was a lie. I didn't make that up. I tell real jokes. I get real laughs. Remember my joke yesterday about the bar? Did anyone think that one was funny? Probably not. So assault, remember assault in parentheses, because in the majority of jurisdictions, it's a specific intent crime, but not in the minority of jurisdictions. Solicitation, conspiracy, false pretenses, assault, larceny, embezzlement, like the theft crimes, fraud, robbery, burglary, forgery, grand theft auto. I think that's what that stands for. A is for assault, S, student solicitation, C, conspiracy, F, fake, false pretenses, A, assault, laugh, larceny, E, embezzlement, F, for fraud, ridiculous, robbery, bar, burglary, and F, forgery. And then we just added GTA because everyone's just waiting for the video game to come out. It's gonna be crazy when that video game comes out, and the Flanagans across from my house is in the game. So like, you know, you can come blow up my house in the video game if you want. Okay, are there any strict liability crimes for which the prosecution need not prove the defendant's culpable mental state? Yeah, we talked about some of these. Statutory rape, sale of liquor to minors, bigamy and polygamy, littering and speeding, possession of a firearm or being a felon. Those are strict liability crimes that you don't need to prove that they intended to do it, right? If Tommy, 40, has sex with Susie, 12, and he thought she was 20, that's statutory rape, right? If you didn't know it was a problem to have multiple wives, but you did, that would be polygamy. Sure. All right, let's see what's going on in the chat. I'm always nervous to see what's going on here. Oh, you guys are asking me real questions. So when you get your schedule for the boot camp, someone's asking me directly. We need to touch base. Everyone who purchased the boot camp, we're gonna have a consultation with you just to get a feel for your strengths and weaknesses. But honestly, we'll probably wait until that emerges, you know, after the proctored exams, and then you'll get your schedule because your schedules are tailored towards your strengths and weaknesses, but we still need some time to figure what they are. Let's see what the next question is. Curious as what the proctor's exam look like. Do we log in to use it for Zoom, and what questions do we use? Yeah, you're gonna love our proctor exam this time. Brand new questions. It's gonna be 100 question tests, and yeah, it's logged into Zoom. The only thing we're working on right now is because we're using Thinkific. The only thing we're working on right now, and I can't promise it'll change, is right now you get the answer immediately. You know, you take it and it tells you the answer, which is not ideal. We're trying to find a way to turn it on the test mode, but what we'll do in the alternative is put them on Thinkific and then give you a PDF so you can print it out and do them all like that and then grade it yourself. So we'll give you both options. There we go. Solved it while I spoke. Okay. Is the proctored exam separate from the boot camp? Yeah, the proctored exams are part of this course. The boot camp is going to have its own different exams. The exams at the boot camp are going to be a lot of questions you've seen before just by nature of doing disclosed questions, but I will add some other questions that you haven't seen. Yeah, exactly. Someone stays on camera. Yeah, I'll have someone I'll have one of my proctors do it where they stand here and they say ready and begin, and then they get paid to do nothing. It's a pretty sick job. I would do it if I was them. And then thanks, no way. That's illegal. I don't know what we're talking about. Okay, cool. Chat room destroyed. All right, number 7. The Model Penal Code lists 4 different types of culpable mental states. Name and define them. Negligence, recklessness, knowingness, and purposefulness. So negligence is you fail to act reasonably. Recklessness is even less reasonable, like gross and unsafe disregard for consequences. Knowingness is like you were aware of it, you knew. And purposeful means you did it intentionally. Willful blindness is the idea that you can't go out of your way to avoid knowing something. Like because I didn't check for IDs, I didn't know he was underage. You can't bury your head in the sand. So willful blindness will not be a defense to the crime. You can't bury your head in the sand. I don't really recommend doing that in general, burying your head in the sand. It might be hard to breathe in such a circumstance. That's what I want to do when it comes to people asking me about my political views. Either that or tell them what I really feel. Okay, what's the difference between actual and proximate cause? Actual is but for, and proximate is foreseeable plaintiff or zone of danger. So actual means like it wouldn't have happened, it's like in torts, but for and proximate foreseeable zone of danger, same concept. When will a third party's action become a superseding or intervening cause? If it completely cuts off liability, if not foreseeable, for instance, intentional criminal activity that breaks the chain. A lot like torts, like if, you plan on doing something, but you don't even get it off the ground because someone else comes in and just does an even greater criminal act. Like I planned on robbing a bank. I walk up to the bank and I'm looking at the bank, I'm scoping it out, and then Tommy comes in and shoots everybody. Like I'm not gonna be liable for their deaths, even though I was planning on doing it because, they came in and were the main cause. What are the elements of murder at common law and in the model penal code? So at common law, we have premeditated malice aforethought, cold-blooded murder. And then we also have depraved heart murder. Like you just shot guns into the air, you just threw a brick off a building, whatever it may be. The model penal code is the intentional killing or intent to cause severe bodily harm or complete disregard to danger putting others in. So it adds that intent to cause severe bodily harm. And then both of them also recognize felony murder as a type of murder. So when I think of murder, which I think about often, right? Every day I wake up with murder on my mind. I usually like to, that's a joke for all you people who don't understand humor. That was a joke too. I know you guys are all hilarious and understand humor out there. All right, don't cancel me. So for murder in my mind, I think of 4 different types of murder. One is premeditated, cold-blooded, malice aforethought, like you planned that shit out and you executed. The other is depraved heart murder. You're just total disregard for human life. You're shooting into the windows. You're dropping bricks off of a building. You're just like doing crazy stuff that people end up dying. Felony murder, like, you go and rob a bank and you shoot Tommy, who's just like standing there trying to take out his last $20. Well, he did get his literal last $20, right? Oh, Rosie, she hated that joke so much she had to bark at it. And then felony murder. Well, we talked about felony murder, and then murder that occurs when you're trying to inflict great bodily harm. So, if you stab someone and all you're doing is trying to give them a nice little stabbing, just let them taste their own blood, but then they end up dying, that's going to be murder because you intended to inflict great bodily harm and they died. If you hit someone over the head with a baseball bat and you're just trying to give them an old whack, they die, murder, right? So these are different types of murder. What I've learned on the MBE is when in doubt, ratchet it up. If you think it's murder, manslaughter, it probably could be murder. Like that's what I've learned from my personal experience, that when you're on the line, it's first degree instead of second degree. It's murder instead of manslaughter. When you're on the line, I mean, if you know what it is, then certainly pick what it is. All right, what's malice aforethought? Cold-blooded, like you planned it out. Anything more than a flicker in your eye. What's a depraved heart murder? Dropping a ball off a building, shooting at a playground, shooting guns in the air. And then first and second degree murder, these will pretty much be statutorily defined in the question, but we can think of first as premeditated and second as everything else. That's the main way that they distinguish first and second degree. Everything else, again, being depraved heart, felony, and intent to inflict great bodily harm. What are the elements of voluntary manslaughter? So homicide, a killing, and adequate provocation. So adequate provocation can be like walking in on the tutor and your wife. That's gonna be my newest funniest joke, right? Walking in on the tutor and your wife and killing the tutor and your wife. That would be voluntary manslaughter. Or the pool boys got replaced by the tutor. That's whoever sent me that message, your fault for making that into my hilarious joke lexicon. So you walk in on the tutor and your wife and you kill the tutor, that's voluntary manslaughter. Another one is the concept of imperfect self-defense, right? Like someone slaps you or someone's threatening you with their hands and you pull out your gun and shoot them down. Like you weren't privileged to pull out the gun, but you still were, adequately provoked. I call it you slap, I stab. If someone slaps me and I stab them and they die, that's going to be adequate provocation. These are all different things. I think the pool boy example, the pool boy is even better than the tutor, honestly, for this one. All right, what are the elements of involuntary manslaughter? Criminal negligence and unintentional, like texting and driving, drunk driving, driving super fast, and killing someone. That's involuntary manslaughter. So make sure you understand homicide. There's murder, the 4 types, premeditated, depraved heart, felony, and intent to inflict great bodily harm. Then there's manslaughter, there's voluntary, which is adequate provocation or imperfect self-defense, and then there's involuntary manslaughter, which is texting and driving or driving super fast and killing someone. How can we distinguish between involuntary manslaughter and depraved heart murder? Well, because it's about the depraved heart nature of it, the disregard for human life versus just being criminally negligent. Like think of driving 90 in a 50 as involuntary manslaughter. That's not depraved heart. That's not like you don't think someone's just gonna die. Like it's not like, come on, I'm driving 90. Like I'm not gonna say I drove 90 on camera because this is recorded, but like I probably know someone who's driven 90 and they haven't killed someone. Like it's reasonable to think that driving 90 in a 50 isn't going to kill someone. Shooting guns at a playground or shooting guns into an office building or just like dropping a brick off of a building, like that is just totally like, I think of like the Joker, you know, like from Batman and the Dark Knight, just like totally like people are gonna die, like ha ha ha, like you just don't care at all. That's what depraved heart is. So just kind of, does that help? Does that distinguish that? Okay, perfect. All right, so what does the model penal code say about manslaughter? Reckless or imperfect self-defense, right? So we talked about that imperfect self-defense, using a gun when someone just comes up with their fisticuffs. Felony murder, when a killing occurs in the commission of a felony, and yes, also found in the model penal code. What crimes can typically also trigger felony murder if a person is killed while carrying them out? This right here is a homage. I'm not making fun of anyone. But it's not bark, it's barar. It's not bark, it's barar. That's just a homage to someone who said that. But it's these are the underlying felonies, right? Burglary, arson, robbery, rape, and kidnapping. Please don't attribute that to me, and please don't put that on social media. That's not my thing. That was a homage to someone else, one of the legends of the craft would say. So those are the underlying felonies that could trigger felony murder: burglary, arson, robbery, and remember, it's RRR, rape and kidnapping. Oh man, I just made my 12-year-old self pretty happy there. Okay, so what are the exceptions to the felony murder rule? So there are some exceptions. You're not guilty for the death of a co-felon. So Tommy and Johnny go to rob the bank, Johnny gets killed, Tommy's not going to go down for his death. And in a lot of jurisdictions, you're not guilty if someone not involved kills someone in some jurisdiction. So some questions will be like, you know, you're robbing the bank, and then the customer comes in and the customer gets shot by the teller. In some jurisdictions, that's the best defense, that you wouldn't be liable for that person. Okay. What are the elements of rape at common law? Carnal knowledge, any penetration, more about force than consent. At common law, it had to be a woman who is not your wife. Under model penal code, it can be a man or spouse. Okay, so at common law, it had to be a woman who was not your wife. You couldn't rape your wife. At under model penal code, you can rape your wife, and men can get raped. I don't like talking about rape, honestly. What is statutory rape and what's the mens rea requirement? Underage, strict liability. A victim cannot be an accomplice to conspiracy or attempted rape or rape. So get that in your minds that like Tommy is 39 and Susie is 7, fucking gross. And let's make it like more realistic. Tommy is 60 and Susie is 15. And we're trying to convict them of conspiracy to commit statutory rape. The 15-year-old girl cannot be a conspirator to a crime in which she's technically the victim of. Not technically, she is the victim of. Strictly such. Okay, 24. What are the different types of theft crimes and what are their elements and what are their similarities and what makes them distinct crimes? So larceny is intent to permanently deprive someone of taking and carrying away. You take it with the intent to keep it. Larceny by trick is tricking them and acquiring possession. False pretenses is tricking them and acquiring title. Money does count as false pretenses because you do have title because you have authority to, use it. So robbery is larceny plus force or threat of force. Embezzlement is keeping money you were in charge of and trusted with, like embezzlement. If anyone was in my course last year, they would get that joke. Burglary, trespass with intent to commit felony, breaking and entering into the dwelling of another at night with the intent to commit a felony therein at common law. But these mostly have been abrogated on the test that you'll see you just need trespass with the intent to commit a felony. So even if the door's unlocked, but you're not allowed to be in there, that would constitute burglary. And you have to have the intent to commit the felony when you are breaking in, not like after you get in there and you're like, oh shit, now I should steal something. It has to be with the intent when you do the actual burglary. What are the elements of robbery and what makes it different from larceny and burglary? So robbery requires force or threat of force. So think of think of burglary as larceny plus assault or battery. And then we talked about the common law definition of burglary above, and most states do not follow this. It doesn't have to be a dwelling. It doesn't have to be the nighttime. It doesn't have to be a true breaking and entering. It's been abrogated in most regards. So what's the common law definition of arson? And do most states still follow this definition? So the intentional burning of another's dwelling must be some charring, not just mere discoloration. And now most jurisdictions allow arson for your own property. So a common law had to be the property of another, but now, most people, when they commit arson, they actually burn their own buildings down. That happened in my hometown when I was a kid. I always remember this burning building down. And I was like a young, astute kid. I was young as shit, but I remember thinking oh, they thought they were tricky. They thought they were going to get away with that one because they burned down the building and they had the insurance policy. But, God sees all. Okay. What are the elements of criminal possession? I don't know why I laughed. That's a true statement. So what are the elements of criminal possession? Knowingly possessing something that is a crime, right? Criminal possession. I'm sure some of y'all are possessing some stuff right now that you're not allowed to possess. I'm trying to get excited for this debate tonight. What are the elements of criminal assault, criminal battery, and how are these different than the elements of tortious assault and battery, and why do you think they're different? This is a pretty interesting question. So criminal assault is the immediate apprehension of offensive contact or attempted battery. There's no attempted battery in civil. And remember, if it's attempted battery as criminal assault, which it is in the majority of jurisdictions, is a specific intent crime. Because even a bar student can fake a laugh for a joke or something. Attempted battery merges into battery. So that's a good point too. If assault is attempted battery, it will merge into the greater crime of battery. That's an interesting piece. Assault as a specific intent crime is also attempted battery. And then assault as a general intent crime would just be placing someone in reasonable apprehension of battery, and then it would be separate from the battery and it wouldn't actually merge into it. You could go down for assault and battery in the minority of jurisdictions that don't recognize assault as attempted battery. What's aggravated assault under the model penal code? Attempted battery with a weapon. It could be a spatula. Honestly, I could fuck someone up with a spatula. No, I can't help myself there. But just think, it doesn't have to be a gun. It doesn't have to be a knife. It could be just some tool that's used for violence. What are the elements of kidnapping at common law? So there has to be an asportation. I wish we wrote that word. That's a cool word. What are the elements under model penal code? So kidnapping at common law is moving from one place to another, and at the model penal code, it's for some particular amount of time. Look for this word asportation, 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 T-A-T-I-O-N. I spelled that wrong. asportation. Look for asportation. That means the movement of another person. So what are the elements of criminal false imprisonment? Same as tortiously, just unlawful confinement. Inchoate offenses, and what's the reason for charging someone with the inchoate offense? Attempt, solicitation, and conspiracy. Attempt and solicitation will merge. So remember that, they'll merge into the greater crime. Inchoate is an incomplete crime. You charge someone because they were being a bad boy, but didn't actually commit the crime. You're not trying to reward someone for being bad at a crime. We want to punish them for trying. right? Like, we're not gonna let people slide just because you're bad criminals. You tried to kill Tommy, you just missed him. You're still going down for attempted murder. We're not just gonna let you on the street so that next time you succeed. The majority rule for attempt is a substantial step. The model penal code is a substantial step or dangerously close. The majority rule requires an overt act. So that's the attempt, if like attempted murder or attempted arson or something like that. You actually have to, come dangerously close or take a substantial step or do something in furtherance of the actual crime. What's the difference between them? That's a good question. I was about to ask myself that. Overt act is doing something towards the crime. A substantial step is taking some planning or something in furtherance. Overt act is slightly more than a substantial step. The dangerous proximity is like how close you are to actually doing the crime. Like if you're dangerously cheesy or not. When is abandonment of a crime a defense to attempt? Do most states follow it? Is it included in the model penal code? So thwarting the crime, not just giving up, but doing something to stop it, actively telling everyone that you're out. And the model penal code does recognize abandonment. Abandonment will not be a defense to the first crime, but will be for subsequent crimes, a lot like withdrawal from conspiracy. So like, you abandoned this, like I'm out, and then they do the thing that you were already, it's too late for to abandon, but then they continue doing more crimes. You'll be absolved of those later crimes, but not the original crime that, by the time you abandoned, they had already, committed to going through.
So quick question with that, Andrew. So what is the rule? You have to abandon it, or you have to abandon it and thwart the crime?
You can't just, you have to take a step to try to thwart the crime. You have to like alert the authorities or, tell the people, hey, they're coming to your house right now. You can't just get cold feet and be like, I'm out, guys. And then you've successfully withdrawn, like, because then you didn't do anything to stop it. The wheels were already in motion. So the withdrawal has to be something, not just giving up, right? But doing something to actually stop it. That is like the, model penal code rule, that you have to actually do something more than just say you're out. Okay, so conspiracy, how does withdrawal conspiracy work? So common law is bilateral and the model penal code is unilateral. This is important. They like to test this. So common law, if you have an undercover cop, it's not conspiracy because there's only one party. At the model penal code, you can conspire with your everyday modern musician, right? An agreement to commit the crime, that's going to be conspiracy. What are the elements of solicitation and what is a renunciation and when is a defense? So asking someone to do the crime, inciting, urging, asking someone to pay. And like we talked about earlier, a renunciation or a withdrawal is like abandonment plus thwarting, doing something to actually prevent it from continuing to happen. So we know that attempt and solicitation merge. When is duress a crime? Not to every crime, never defense for homicide. So the proverbial gun to the head is not a defense to murder. So look for the question where it's like, Tommy's in a gang, and in order to join the gang, he has to go kill someone. So he goes and kills Susie. Well, I'm sorry, it's under duress. It's not going to be a defense for murder. What are the rules for the 4 different insanity tests? We talked about this in Jeopardy. McNaughton, you didn't know right from wrong. Irresistible impulse, couldn't stop yourself from doing it. Durham, the but-for test, and then the model penal code allows for either McNaughton or irresistible impulse. When is self-defense using non-deadly force acceptable? So it depends if it's a retreat or non-retreat jurisdiction. In retreat jurisdiction, if you have no safe way of leaving, and in a non-retreat jurisdiction, only if you're using non-deadly force. Let me think about that. In retreat jurisdiction, if you have no safe way of leaving, right? So that means you're obligated to retreat. In a non-retreat jurisdiction, you don't have any obligation to not use non-deadly force. Like you're allowed to stand up for yourself. I'm not really sure what we're meaning right here. I have to ask Matt. Okay, when is self-defense with deadly force acceptable in the majority of states? For the minority of states that have it, when does a person using self-defense have a duty to retreat? So deadly force when confronted with deadly force, right? You mean apples with apples. In retreat, when you have no ability to retreat, and in non-retreat jurisdictions anywhere. So again, you can use non-deadly force acceptable in a non-retreat jurisdiction if they're using non-deadly force. Oh, that's what it's supposed to say, if they are using non-deadly force. And then same with deadly force. If they're using deadly force, you could use it in a non-retreat jurisdiction. If it's a retreat jurisdiction, which the question will tell you, that means if you have an opportunity to safely retreat, you have to do it before you meet fire with fire. So what's the stand your ground clause in the castle doctrine? So the castle doctrine, you protect your house. You have no duty to retreat in your house. Stand your ground, no duty to retreat when confronted with danger. You can meet force with force. Florida recognizes that stand your ground. Imperfect self-defense, so meeting non-deadly force with deadly force. You can get a murder charge reduced to voluntary manslaughter or killing a bystander trying to defend yourself unreasonably. So imperfect self-defense is like a type of voluntary manslaughter. When is voluntary intoxication an offense to a crime? And when is voluntary intoxication a defense? So voluntary versus involuntary. So voluntary specific intent crimes like murder, you can't go down with first degree murder, or you can't go down with, larceny or something like that if you're hammered, right? Because you don't have the mental state. Unless it's like liquid courage, like I'm going to murder Tommy, I have it all planned out, I stop at Flanagan's, drink 2 beers, and then go on with the murder. Like those 2 beers were liquid courage, let's say. That's not going to be a defense. Involuntary is always a defense. What's involuntary intoxication? That means like someone drugged you, right? And by drugging you, you went out and stole the watch, but you were roofied, let's say. That would be a defense. Mistake of fact. When is defense of others a defense to crime? If it's reasonable for them to defend themselves. So defense of others, you can pretty much stand in the shoes of another to defend yourself. When is mistake of fact a defense to a crime? If it's to negate specific intent, right? Like if you needed to show larceny, right? And you thought that you were stealing something, but it was free, then that would be negating it. Like, how could you steal something that they were giving out for free to the public? So, all right, is mistake of law ever defense? Like thinking what you're doing is legal is never defense unless reliance on valid official in charge of saying the law is incorrect. Thinking what you're doing is illegal, but it's actually legal will be a defense, right? So mistake of law is not defense. Like, oh, I didn't know it was illegal to fucking steal watches from the jewelry store. Like, no, you're going down. The opposite is a defense. If it's like, oh, I'm going to do something. I'm going to steal this pamphlet. And then you sneak up and you steal it, but it was free. That's actually going to be a defense. So this was a pretty hefty questionnaire. And the thing is, there's also another questionnaire. For the sake of time, I might wait until the workshop this Sunday to do that. Let me just take a look at it and see how long it is. But that was pretty solid. Wait, that's the one we just did. Sorry. Actually, I think maybe there only is one. I think Crim Law and Crim Pro are combined. Maybe I'm just confusing myself because that's the Crim Law one, and then this is the Crim Pro one. Oh no, okay, that was the Crim Law one. We still have the Crim Pro one to do, which is 39 questions. Yeah, I'll probably wait until Sunday to go over this. Let me just cruise through it, pick on some of the good points, and then we'll talk about some cram guide pieces, and then I'll let you watch this debate, even though it seems like there's only 8 people in the room who are undecided. But if you live in Florida, I don't think it matters. Florida's probably going to go the same way it's gone in the past. But anyway, so the 4th Amendment, we talked about reasonable expectation of privacy. I mean, we'll go over this on Sunday about some of the places you definitely need a reasonable expectation of privacy, when you have it, when you don't have it. When is an arrest when you deprive someone of their liberty, which, would require Miranda if you're doing interrogation. Stop and frisk when criminal activity is afoot. The cops could do a reasonable pat down for weapons. And then if they find anything that feels like, contraband, they could seize that as well. Right? That's the plain field doctrine. So reasonable suspicion, it looks like something's afoot, like you can pull someone over, and then probable cause, it's likely, like, the dog smells it in the trunk, it's likely he's going off for a reason. Warrants, Caro killed this one. When do you need a warrant for search or arrest? And you need it for a reasonable search and seizure. For it to be valid, probable cause, oath or affirmation, describe the persons, places, things to be seized. Everyone needs to know the spaces mnemonic, search into arrest, plain view doctrine, automobile exception, administrative search, consent, exigent circumstances, stop and frisk. Those are definitely the main exceptions. And we go over them. Over here, we talk about exclusionary rule. Anything that's taken in violation of the Fourth Amendment will be excluded and suppressed. And the fruit of the poisonous tree doctrine, you know, so too. Any of the fruits will be suppressed. Fifth Amendment, we know pretty well. I plead the fifth. Sixth Amendment, speedy trial, right to counsel after adversarial proceedings have begun, confrontation clause. Miranda rights we talk about, you should know them pretty much by now. So if Miranda rights are violated, the statement can't be admitted, but it could be in a grand jury proceeding because the rules of evidence don't apply in grand jury proceedings. 14 days usually for if you've invoked Miranda rights, invoked silence for them to interrogate you again, they have to ask you again, Miranda rights. Custodial interrogation, it's in custody when you don't feel free to leave. You no right to counsel at a pre-arrest lineup, but you do at a post-arrest lineup. Fifth Amendment is before adversarial charges have begun. That's when you have a right to counsel. Sixth Amendment is after. You could sue your attorney for ineffective counsel and, you know, he sucks. Unduly suggestive lineup, right? Suspect is 5 feet tall, but you put a bunch of 6 feet tall people in there. You know, obviously they're gonna know the one guy who stands out, that unduly subjective. Criminal right to a trial, right to confront, right to have witnesses, right to have counsel, right to a unanimous decision at the federal level. Competent jury, double jeopardy, can't be charged twice. Right, like the Blockberger test, meaning if you are, you can't go down for attempted murder and murder, right? If you're convicted of the murder, then you're not going to go down for the attempted murder as well because, you know, it merged into it. It has the same element. Or larceny and robbery. If you're convicted of robbery, you can't go down for larceny because robbery is larceny plus, you know, assault or battery. Jeopardy attaches after the jury's been impaneled in trial and in a bench trial when the first witness testifies or evidence is introduced. Excellent job, everyone. The burden of proof is, you know, beyond the shadow of reasonable doubt, and the prosecution has this burden. But affirmative defenses we talked about, it could be lowered to like preponderance of the evidence or even clear and convincing. Can the judge overturn a jury finding in a criminal trial? And if so, when? A JMOL, for instance, but not a guilty or non-guilty verdict. And the harmless error rule, if there's a prosecutorial misconduct, but if had the same conduct, it's all good. The outcome would have been the same even with the error. That'd be a harmless error instead of, you know, something prejudicial, or that was a plain error that they had to overturn. So I know I went over that quickly. I'll go over it again in a little bit more detail on Sunday when we do the crash course. And then the last thing that I just want to go over and pick out some interesting points are these cram guides. I mean, this one's pretty short, and we have other ones, but you should work on these. So let's talk about some of these. If a person is guilty of attempted murder, a person is guilty of attempted murder when she takes a substantial step, more than mere preparation, towards completion of that crime with the intent that the murder takes place, right? That's a substantial step for attempted murder. If a person is drugged and uncontrollably hits someone, it's not battery because they did not have the intent to commit the act that resulted in the offense of touching, right? Remember, involuntary intoxication will always be a defense. If a robber asks a maid to leave the door open so he can rob the house, and the maid pretends to but calls the cops, the robber can be found guilty of solicitation, but not conspiracy under the common law bilateral requirement for conspiracy, since the maid never agreed to partake. Remember, at common law bilateral requirement for conspiracy, you're not going to be able to succeed there. This one is a tough question. I've gotten this one wrong, I think the first time I did it, but hopefully you all get it right because you've seen this. If a robber tells a clerk, give me the money or I'll hurt you, and she faints and hits her head, this is attempted robbery, but not assault because there was no overt act and words alone are insufficient. If you know that you're buying stolen property, but you don't partake in the stealing of the property, you cannot be convicted of conspiracy to steal since you did not have any involvement with the theft, right? Maybe you can have receipt of stolen property, but not conspiracy to steal because it's after the fact. So strict liability for statutory rape, food safety laws, etc. Usually the firing of a warning shot or something similar will constitute second-degree murder because it's reckless disregard for human life. So typically, first-degree murder is malice aforethought, and then everything else will be second-degree murder. So this firing a warning shot, if you fire a gun into the air and it hits someone, that would be reckless disregard for human life. Murder is the intentional killing of another with malice aforethought. So just being a witness to a murder does not constitute being accomplice, right? If you just stand there and watch, even if you're like, good luck running away, Tommy, like you encourage them, that's not going to be enough. You have to actually aid and abet them to be an accomplice. To be found guilty of attempted murder, a defendant must have the intent to commit a murder and take a substantial step towards the commission of it. We said this one again. If a defendant tries to shoot his neighbor, but is out of the distance range, but does not know he is out of distance range, this still constitutes attempted murder. That's a tough question, right? So you're shooting the gun at Tommy. Tommy's 50 feet away. Your gun only goes 40 feet, but you tried to shoot him. That's still attempted murder because you had the, mens rea, the specific intent to murder him. And just because it was impossible under the circumstances doesn't matter because you actually tried to murder him. In homicide, the actions must be actual and proximate cause of the victim's death, but they need not be the sole cause of death. For example, a man who poisons another man is guilty of homicide, even if other factors besides the poison contribute to the death. It just has to be a contributing factor. If you shoot a person intending to inflict harm and they die, you can properly be convicted of murder because you intended to inflict great bodily harm and it resulted in a killing. If you pickpocket a drunk person passed out on the street, you're a piece of shit. You're guilty of larceny, even if you give up the property when you hear the police coming. Like once you take it, you're guilty of larceny. They like to test that too. Like you're in the store, you take it, take 3 steps, and then have a moment with God, and you say, "I'm not doing this." Larceny. You already had the elements satisfied. So drunk driving through a playground, maybe in a video game, right? But in real life, that's going to be reckless disregard and indifference for human life theory. Yeah, I feel like when Grand Theft Auto comes out, Miami's going to see some wild shit because people are going to be too like reality is like the video game. Shooting a bullet at your neighbor's house because they're having a party and killing someone also constitutes murder under the same theory, right? Larceny by trick, again, just taking the thing, false pretenses, you have to obtain title. You can't rob a sleeping person because they must be aware of the force. This would only be larceny, right? Just like, okay, as a tort, you can't assault a sleeping person. As a crime, you could, in the majority of jurisdictions, assault a sleeping person if it's attempted battery. This last 2 questions, failing to take an ill child to a state medical center and the kid dies amounts to criminal negligence and the father can be found guilty of involuntary manslaughter, blatant disregard to an unjustifiable risk of harm, right? That's a failure to act that would constitute, involuntary manslaughter. Once a stolen property is recovered by police, it loses its stolen status. So I really hate this question, but hopefully we all get this right if you see this one. So once a stolen property is recovered by police, it loses its stolen status. Therefore, if the police resell recovered property undercover, the buyer cannot be guilty of receipt of stolen property, right? Because something was stolen, but then the police recovered it. Once the police recovered it, the item is no longer stolen. It doesn't have that status of being stolen. So if they, someone buys it from them or they give it to them, even if they try to get it being stolen, it's not receipt of stolen property because it's lost its stolen status. However, if an undercover agent is acting with another person to steal property and then it is sold, the property has not been recovered by the police and the recipient could be found guilty of receipt of stolen property. So in that question, the answer is, when are they guilty of receipt of stolen property? It's when they're working with the cop to steal the property and sell it, not when there's a car that's stolen that's recovered by the police and then someone buys it not knowing that it's police, thinking it's stolen because it no longer has a stolen status. That was a really tough one to end on, so maybe I'll scroll up and do one more. Yeah, let's talk about burglary. Burglary is a specific intent crime. It requires the intent to commit a crime therein, meaning if someone breaks into a building with no intent to commit a crime and then decides to commit a crime, it's not burglary. The intent to commit the crime must exist at the time of the break-in. So I think, today we did a good mix of activities that tend to work in totality. Those are doing the questionnaires, doing the cram guides, and then on Sunday, we'll do live questions. So I really appreciate everyone for sticking it out with me. I hope the debate is entertaining. That's all I'm really interested in. And yeah, enjoy the night. Thank you all so much. I'm gonna stop this recording.